Hello, this is Attorney Mike Gravel coming to you from Chicago as usual, and we have got a Swiftie update. Oh yes. Our favorite Swiftie, who's always in hot water, continues to be in hot water. So here's what we have. I've got the last two court appearances. The one of the court appearances I streamed during a trial stream, so a lot of people didn't see it. It's short, but give context in court appearance. The big question we're all wondering is, can our Swiftie bust out of the clink?
2401-248.
Good morning, I'm Attorney Joey Phillips, PA 401 on behalf of Ms. Ellis on the 1248 matter.
Hey, good morning, Your Honor. May it please the court, George Brown on behalf of the defendant in the other matter that's up this morning.
Ms. Ellis, state your name.
Megan Ellis.
All right, today's date and time set for pretrial in this matter. There's continuing efforts to try to resolve this, but it's also my understanding that Mr. Brown was recently retained and in the meantime is making a request of this court for a reduction in bond. The court notes, although the prosecutor's not here, the prosecutor is objecting to any reduction at this time. But I certainly want Mr. Brown, Mr. Phillips, whatever you want to place on the record. Mr. Clusie, I just indicated that you were objecting to a bond reduction on the Ellis matter. Is that correct?
Yes, Your Honor.
All right. So, Mr. Brown, my intent right now is I'm willing to listen to a proposal related to a structured bond reduction. From what I heard in the breakout room with both counsel present, there wasn't sufficient sort of specificity to what would be sort of the plan once she's released. I think it's something that you can acquire, you and Mr. Phillips can acquire in short order. Normally, I would just set this for my next available Royal Oak date, which would be next Monday. But recognizing that Miss Ellis continues to be in custody, and really the determination by you and Mr. Phillips to get this before the court, I'm willing to adjust my schedule to see her my next criminal day.
Oh, we know.
Even though it's a Berkeley day, which would be this Thursday. What I would be looking for, though, Mr. Brown, is I really need to know where she would be staying. And I need to have some verification of, like, who's there with her. Would she be on her own? I want to know, is she going to be able to get the type of assessment that I'm looking for? And can that happen in a very short time frame after release? Is she willing to follow my rules? I need to have some basic understanding that Miss Ellis recognizes that when I set bond conditions, they're non-negotiable, and they have to be followed. And really, in the end, it's about making sure that the process works. That that she's able to have a fair opportunity to challenge her domestic violence case and this disorderly conduct case, while remaining out in the community. But I need to make sure that certain safeguards are put in place. But in the end, I could put as many safeguards in place as possible. If she's not willing to follow them, then we're all stuck. And so that's what I want to make sure by Thursday that I have from you, Mr. Brown, and Mr. Phillips. This, if I amend it back to a personal bond, this would be the plan, and some sort of verification from Ms. Ellis that she's willing to follow it. Mr. Brown, Mr. Phillips, is that a timetable that, if I can open up my docket for a Thursday morning, can you both be available for that day, Mr. Brown?
Yes, Judge.
Mr. Phillips?
Yes, Your Honor.
I mean, Ms. Ellis, you should understand, your attorneys are certainly pressing the court for your freedom.
I understand.
But at the same point in time, they can only do as much as whatever you're willing to comply with and whatever information you give them. So
I'm willing to comply with any of your stipulations. I have always been a rule follower. This is the only time I've ever been in trouble, is this summer.
Well, Ms. Ellis, I'm hoping that I believe that both your attorneys are going to be able to come up with a game plan that I can follow. Mr. Kluzny, obviously, you'll be able to express any objections or any concerns on Thursday morning, and we can go through all of that. But I think there is a plan that would allow for the safety of the community to make sure that she returns to court as directed outside of the jail setting. Today, I don't have enough information, but I think Mr. Brown and Mr. Phillips can deliver that on Thursday, and we'll see everybody back together here Thursday morning at 8:40 or 9:01 because she's in custody. I think that's the earliest I can get her here.
Is that me as well will be there, George?
You will absolutely be there. There's not going to be a court date that you're not going to be a part of. You will be there 9:01 a.m.
George, can we break out after?
No, you can't. We can't do a breakout, Your Honor.
I'll set
Yeah,
up a
no,
meeting.
we're done. This is taking enough time, Deputy. I appreciate your
I'll
patience.
set up a meeting with you.
Thank you.
Certainly a challenging, lengthy process, and I appreciate you. Good luck, everyone. Thank you.
Your Honor.
Thank you, Judge.
Okay, calling case numbers 2401-451, 2401-248, People versus Megan Ellis.
On behalf of the people.
And George Brown on behalf of the defendant on the disorderly case.
Attorney Joey Phillips on behalf of Miss Ellis on the domestic violence case.
Ms. Ellis, state your name, please. Ms. Ellis, are you there?
See, she's muted, Your Honor.
Well, she should still be able to hear us. Ms. Ellis? I don't know if there's a...
I know they were having issues when I talked to her.
Yeah, those tablets have been freezing.
Ms. Ellis, are you there? Ms. Ellis, can you hear me?
Yes, I'm here. Yes, I can hear you.
Okay. All right, today's date and time set for pre-trial and bond review.
No, I.
Hold on. Ms. Ellis, are you hearing us right now or in the middle of the proceeding? I want to make sure you can hear everything that's going on.
Yes.
Connor, this is the deputy. I'm going to try to connect the iPad to Wi-Fi real quick.
That's fine.
Hear you. If you want to keep talking, it's up to you, Your Honor.
It's fine as long as she can hear me.
Yes.
If at any point in time, well, I'll keep checking in from time to time to make sure you're still continuing to hear us. Mr. Brown, Mr. Phillips, I know you have a request related to bond. Obviously, bond was set based on the new charge in an increased level. We were last here on the 5th. Before that, the 26th. The court had expressed its concerns about Ms. Ellis's likelihood to comply, potential danger to the community, and I put it on defense counsel to come up with a plan that the court could feel comfortable with that would allow her back into the community. So, Mr. Brown, I know your request and Mr. Phillips' request is for the court to consider reinstating a personal bond on the domestic case and amending to a personal bond on the disorderly matter. I'd like to hear what your proposals are, starting with Mr. Brown.
Yes, Your Honor. When we were last here, the court did have certain concerns and asked for a plan. So the court was not going to do anything without some kind of plan. So we did put together a specific plan to address those concerns. We would suggest that the court, yes, grant personal bond in both cases, order that Ms. Ellis go to a psychiatric evaluation with Dr. Michael Abramsky. She already has an appointment with him tomorrow at 7:30 p.m. He's expecting her, and he's already been provided with some background information on her situation. Also, the court wanted to know where she would be. Ms. Ellis does reside in Royal Oak. She has a home that she owns and pays a mortgage on. And finally, the court wanted to hear from the defendant herself, whether or not she was willing to follow court orders. I've spoken with her many times about this. I am convinced she is absolutely going to follow court orders. And she's prepared to address any questions the court has about that.
Thank you, George.
All right, so let's start a couple things. Miss Ellis, I have a number of concerns related to this. Actually, before I start addressing Mr. Markham, I want to make sure that you have a chance to be heard on this call. What's the position at this time on defendant's request?
Thank you, Judge. Would just like to say for the record, the court is in possession of several videos or videos that the court has watched and discussed. City's concern is there's some sort of mental health issue that needs to, and I believe that's consideration as well. My only problem with the plan as it stands is that it does put that on Miss Ellis to herself agree to attend and actually attend those proceedings and any follow-up that's needed. However, I understand from speaking with counsel that the opportunities to have someone come to the jail or have her directly transported are fairly limited or non-existent. So this may be all that we've got. So that said, I do leave this ultimately to the court's discretion. However, and I believe there probably is a no weapons restriction on the domestic violence bond and probably the other bond. I'd like the court to expand that for her to.
He's reasonable. He's about where I'm at, which is I'm really skeptical about all this. But okay, give it a try if you like.
Also not be in the presence of anyone in possession of a weapon.
Fine. I don't own any weapons in my home.
Mr. Phillips, I trust you joining Mr. Brown's request.
That's correct, Your Honor.
All right, so here's my concern, Ms. Ellis. I need to make sure that you understand that if you don't show up for that psychological evaluation, I'm going to issue an immediate bench warrant, and you're going to be exactly where you're at right now. I would hope that after the time that you've spent in jail and sort of the nature of the allegations and the behavior, that there's a part of you that wants to know what the heck is going on and try to figure out how this happened, where someone who prior to this incident, we don't have any type of interaction with the criminal justice system, and then a significant set of interactions with the criminal justice system, including commentary on videos with the court is aware of, which are, I think it's fair to be described as very threatening and very disturbing. And so I would imagine in your shoes, you would want to know how this came to be, and the best way that I can think of to
By the way, I'm trying to get these videos. I've elicited the help of Bama Mike.
to gain an understanding is for you to somebody, a professional who can evaluate the situation and give you a roadmap for how you can prevent this from happening, prevent yourself being at behind bars. But if you're not willing to go down that path, if you're not willing to explore and do that sort of self-evaluation along with professional assistance, then that just tells me that you don't want to know, you don't care, and that's a dangerous person, and you'll be exactly back where you're at right now. So,
I'm more,
Ms. Ellis,
more
ahead.
than,
go ahead. What'd you say?
yes, I said I am more than willing.
Okay. All right. It's the order of this court. One, I'll just set this for a pretrial in 2 weeks. That'll give you a chance, Mr. Brown, to get started on this and really get into the facts of the case. Give Mr. Phillips a chance to continue to evaluate the case against Ms. Ellis and the domestic matter. I'll amend this to a personal bond. However, there will have to be a GPS tether prior to release. I am going to require that she engage in drug testing twice a week. I know there was some discussion related to alcohol. Obviously, she's prohibited from using alcohol, drugs, any illegal controlled substances, any mind-altering substances. But for now, my main concern would be related to the drug testing. If it comes out that she's using alcohol, then I'll add alcohol testing, but I'm not going to add that for right now. She's not to have any possession of any weapons or be in the presence of anyone with any weapons. She's not to be in the presence of anybody who's using alcohol or controlled substances or any mind-altering substances. She needs to stay away from all of that. While she is home, all right, because that's where I will be releasing her to. While she's home, she is not to engage in any use of any form of social media. All right, there is to be no logging in just to read or scroll, no posting. It's my understanding the allegations from the people related to the videos that were sent with this was a Snapchat video. Is that correct, Mr. Markham? Oh, you're on mute.
I believe that is correct, Your Honor.
Okay, so I don't want your TikTok, whatever. You're away from those things while you're working on your mental health. you should be away from that stuff anyway. But since I have evidence of extremely negative behavior related to social media, you're off it. Don't go on it. Don't go check on it. Don't like anything. Don't send any messages. If I hear or see anything like that, you're back exactly where you're at right now. Do you understand that?
Yes, sir.
Okay. I do want her to do a daily journal of her activities and get that to your attorneys. So Mr. Brown, Mr. Phillips, and if you could just submit that to the court once a week, I'd appreciate it. But she's to get you that information. All right. Just have her log what she's doing. We want to keep her involved with healthy behavior. Now, she is required to be at home, all right, from 8 p.m. to 8 a.m. If she needs to be somewhere else, she can ask permission through her attorneys. But from 8 p.m. at night till 8 a.m. in the morning, she's home. And obviously, she's required to be a minimum of 1,000 feet away from the victim. The GPS tether will be able to manage that. The psychological evaluation is set for August 9th at 7 p.m. with Dr. Bransky. She must appear with the doctor and follow any treatment recommendations. She's to surrender her passport. And just remember this, Miss Ellis, if this court has probable cause to believe that there's a bond violation going on, you are at all times going to be subject to a search of your home for substances and weapons. So just be very aware of that. All right. So that if this court believes that you're using, this court believes that you have access to weapons, your home could be subject to search. Do you understand that?
I do understand that. So one quick question, like I have a mini bar downstairs with alcohol that just sits there and collects dust. Do I need to get rid of it all?
Yeah, absolutely. All
Okay.
that needs to be gone. That needs to be out of the home.
Okay.
All right. In fact, if you have someone who has access to the home, a friend or a family member, they should work on getting rid of that before you even step foot in the home.
He'll take care of it all. Yeah.
Okay. Mr. Brown, Mr. Phillips, anything in addition to what the court's put on the record that you want to address?
Yes, Judge, just a couple things. One, the appointment is for 7:30 tomorrow on August 9th.
Okay, 7:30. Thank you. We want to be accurate. Appreciate it.
Oh.
And additionally, Your Honor, I just want some clarification. I don't want to come back here on just a misunderstanding. So Ms. Ellis is to be at her house from 8 p.m. to 8 a.m. She may travel outside of the house during the other hours?
Correct.
Okay, thank you, Judge.
If she has to go to get groceries, go to a doctor's appointment, things like that. But she is to be at the house the rest of the time. Now, if I find out that she is, taking advantage of that and choosing to engage in certainly self-destructive behavior, the court can just limit her to just the house and that's it. Ms. Ellis, I would prefer not to do that. I prefer to see you try to get a job, try to get yourself back on your feet. And I think giving you that space would give you a chance to do that. But if you take advantage of that, then you're going to put me in a position where I have no choice. I have to put you back in jail. I can't stress this enough, Ms. Ellis. I'm still very uncomfortable. You've given me many reasons to be uncomfortable. I'm hoping for the best here. I think I've put enough safeguards to protect the community, protect you from yourself. But please don't mistake my desire to see you in the best possible position mental health wise. Please don't mistake that as an unwillingness to do what it takes to keep everybody safe. And that includes locking you up. So I'm giving you a shot here. Follow my rules and you can stay out. And more importantly, I don't think she's going to, gain any sort of personal growth or get some additional information on how to address any mental health concerns that may exist while sitting in a jail cell. So this is our chance to really get to work. But Ms. Ellis, this is going to be on you. As Mr. Markham says, that's the big fear right now is a lot of this is on you. But I would hope that the jail sentence the time in jail will have motivated you to do whatever it takes to take care of yourself and understand how this happened. All right, good luck.
Thank you.
Mr. Markham, Mr. Phillips, Mr. Brown, thank you for your time on this. Everybody's working really hard on this, and I just hope that Ms. Ellis will meet us all in the effort that we're putting in by putting in the same effort herself.
Understood, Your Honor. Thank you very much.
Thank you, everyone.
Thank you, Judge.
Thank you.
Heck, it's a double rainbow. Hey, Cal, look at that. It's a double rainbow.
Well, there you have it. There you have it. Our favorite Swiftie has busted out of the clink. It's official. It's sort of interesting. I'm skeptical as hell. Apparently the judge is too. Although he let her do it. I don't really have a problem with this result. I thought he was a little too soft on her, but he feels actually sort of the same way. Having said that, she has sat a couple days in jail here, and that should get her attention. It's beyond my scope to figure out if she's got mental health issues. She's going to a doctor for that, although I'm leery of that, a doctor for choosing. And she may have a substance abuse issue, or it may just be as simple as an extreme sense of entitlement that may have been solved by sitting in jail. I will give her credit in these two appearances. She is on point. But that, I can't distinguish. That might be because she's not altered, or that might just be the humbling experience that woke her up from her entitlement. I don't know. I'm pulling for her, but I remain skeptical. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.